Well, hello everyone, and welcome to this Federalist Society virtual event. I'm Caroline Bryant, and I'm the Deputy Director of Networks at the Federalist Society. Today, we're excited to host this litigation update on President Trump's anti-DEI executive orders and the lawsuits challenging them. Our panelists today are the Honorable Andrew Gould and Mark Pinkert. Andrew is a partner at Holtzman Vogel and focuses his practice on appellate, commercial litigation, and constitutional law. Prior to joining the firm, Andrew was a justice to the Arizona Supreme Court from 2016 to 2021. Mark is a litigation appellate partner as well. He represents clients at every stage of litigation in state and federal courts around the country. He has extensive experience in constitutional law, administrative law, political law, antitrust, white-collar defense, and complex commercial disputes. After our panel gives their presentation, we will turn to you, the audience, for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we will do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our guest speakers, not the Federalist Society. With that, Mark, thank you so much for joining us, and the floor is yours.
Thank you, Caroline, and thank you to the Federalist Society for hosting this podcast. We're really excited to be here, and I'm excited to be joined by my partner, Andy Gould, who, as you said, Caroline, is a former justice of the Arizona Supreme Court, also a former appellate and trial court judge. So what we'll do today is I'll discuss some interesting developments in the area, and he'll give his perspective from the bench and as a jurist. And we apologize, our partner, Jonathan Fahey, was supposed to join us. Can't make it. He had an emergency. And Andy, feel free to disagree with me, but I do think that in his absence, the IQ of this podcast has gone up substantially.
It'll go up at least a third.
At least a third, exactly. So today's topic is DEI litigation, like Caroline said. After taking office, President Trump issued 3 key executive orders with the very broad goal to dismantle DEI in government and in the private sphere. And needless to say, the executive orders and the subsequent agency actions prompted a flurry of lawsuits. And there have been several very interesting developments. Things are still in a state of flux, but we're going to kind of take you into what's happening on the ground and give you our perspective. But a lot more will happen in the next few months, and maybe Caroline will have us back to do another update. For in-house counsel listening in, I think that it's important for you to be aware of these developments. It's moving very quickly, and a lot is happening in the space that can affect your company's employment practices, your applications for federal grants or contracts. And it's also important to know, what's going on with these in the enforcement landscape to avoid potential enforcement actions from the Attorney General, from state attorneys general, and from other agencies. For generalist lawyers listening in, I think these cases are interesting not only because of the subject matter. If you're interested in employment law, civil rights law, anti-discrimination law, there's a lot here. But the cases are also noteworthy because of some key legal issues related to Article 3 standing, the Administrative Procedure Act. There are questions about nationwide injunctions and judicial remedies, questions about separation of powers, the First Amendment, the Fifth Amendment, and statutory interpretation. So there's really quite a lot to cover and a lot to unpack. So we'll try to get through everything that we can within the hour. But with that, let me turn it over to you, Andy, to ask you a question, which is what is, and this is a fundamental question for this conversation, what is DEI from your perspective? Is it an open-ended and vague sort of academic or cultural concept, or is it something that can be distilled and articulated as a set of policies that can be adjudicated by a court? This is, I think, an important question not only for the discussion today, but a lot of the legal arguments that we're going to talk about are about, for example, Fifth Amendment void for vagueness doctrine. So I think it's important to define what it is we're talking about. So what is DEI from your perspective?
Well, thank you, Mark. The best way I can approach that is how I would approach it as a judge. And judges can handle discrimination. That's a concept that it's well embedded in the law. It's easier to draw the lines. What are protected classes? Those sorts of decisions are just much more clearly defined legal categories and legal issues. When you get into DEI, you start bringing in concepts of equity and inclusion that are much broader, and it's much harder for a judge to analyze those issues because like it or not, those are cultural issues, they're social issues, and judges are not social workers, they're lawyers. So when you start putting those concepts in front of a court, it becomes more and more difficult for judges to rule on those. So I think as a concept in the courts, I struggled with it. I see judges struggling with it because it goes far beyond just discrimination.
Yeah, absolutely. And we're going to see that play out in some of the cases as we get into them. Let me just talk about President Trump's three major executive orders that he issued immediately after taking office. This is really the subject of the litigation that we're going to be talking about. The first executive order is 14151, entitled Ending Radical and Wasteful Government DEI Programs and Preferencing. This is an executive order really targeted at the federal government itself. It tells the Office of Personnel Management and the Attorney General to revise all employment practices within the government, all training, anything that has DEI within it. Let's get rid of it in government. If you think of the federal executive branch as a business, the CEO is saying no more DEI policies, no more DEI offices or positions. And it's a very sweeping executive order. It also demands a list of grantees, that is private parties who are getting money from the federal government and grants and contracts to promote DEI. And it directs all executive agencies to terminate any equity-related grants. So that we'll refer to as the grant termination provision. As we'll see, that's one of the provisions that has been subject to a lot of litigation. The next executive order is 14173, Ending Illegal Discrimination and Restoring Merit-Based Opportunity. This is a sweeping executive order that extends not only to the public, but also to the private sector. So it's very broad in its reach. The first thing that it does is it rescinds all DEI-related executive orders, not just during the Biden administration, but going back to the 1960s with LBJ's executive order for federal contracting. And then in turn, it sets all of the executive agencies in motion with respect to their relevant industries, telling them basically to dismantle DEI. So very, very ambitious executive order. Two key provisions, again, that are subject to litigation from this executive order. The first is the certification provision, which requires all agencies to include in every single contract or grant award going forward a certification from the award recipient that this federal contractor is not operating any programs that promote DEI in any way. And if the grantee happens to be doing that, they could be subject to False Claims Act liability. So that's what we'll call the certification provision. Then there's an enforcement threat provision, which directs the Attorney General and all other agencies to take appropriate measures to basically deter all DEI in the private sector. So enforcing anti-discrimination laws in a way that will deter private companies, businesses from using DEI in their practices and policies. Attorney General Pam Bondi issued a memo shortly after that, sort of reflecting that for the Justice Department. So that's the second executive order. The third executive order is 14168, Defending Women from Gender Ideology, Extremism, and Restoring Biological Truth to the Federal Government. This defines sex as an immutable binary. It removes gender identity as a concept, at least in the policy of the federal government, and similarly prevents grants or requires agencies to terminate grants where the grantee is promoting gender ideology. So in the wake of those three executive orders, you've seen a lot of flurry of activity from major corporations, some announcing very substantial DEI rollbacks, others reaffirming their commitment to DEI. There's really a broad spectrum of what major corporations have done. But Andy, let me get your take on this. If you can go back to January, rather than your perspective on the bench, if you were in-house counsel, how do you react to these executive orders, and how do you instruct your business or your company to deal with them?
Well, Mark, they're going to be tough to navigate. I'm stating the obvious. These executive orders really push the envelope in a lot of areas of law that courts haven't addressed before. we don't have a lot of precedents in these areas as well. So there isn't going to be clear case law. And we'll talk about this later, but the way a lot of these are coming up, it's in the context of preliminary injunctions, which really multiply litigation and still don't give clear direction because it's a different set of factors that a court's looking at versus a final judgment or a permanent injunction. With that, you also have a combination of a DOJ and EEOC divisions and commissions throughout the country being much more aggressive in rooting out some of these practices. Years ago, and I'm sure a lot of the in-house counsel lived in this environment, you're really just looking to get your right to sue letter. Now, Mark, you've had experience with this. I've had experience with this in some of the cases I've been on. The EEOC actually does an investigation, a real investigation, and is taking some of these issues very seriously. And DOJ is talking about, in some instances, will actually file the lawsuit. So it puts employers between groups on one side that are very supportive of DEI programs that are very embedded in HR departments versus DOJ and an EEOC commission that is very committed to rooting out these practices. And then in the meantime, you're going to have very robust investigations once these claims are filed with the EEOC. So it's kind of a difficult combination of these administrative orders, or excuse me, these executive orders pushing the envelope in areas that there isn't a lot of precedent in the context of preliminary injunctions that aren't very clear, that are going to hang around for a while, and then EEOC commissions and DOJ pressing employers from the other side. So it's very different, excuse me. In my almost 36 years of practice, I've never seen anything quite like it.
Yeah, and if I could add to that, I think what's unique about the enforcement environment is not only the fact that you've got sort of anti-DEI enforcers at the federal level and the EEOC being more aggressive than it has in the past. You also have red state AGs who are bringing anti-DEI civil enforcement actions, and we'll talk about that a little bit later. And you also have blue state state AGs who are committed to DEI and may be looking to bring counter lawsuits. You also have potential issues if you loudly and explicitly roll back DEI. You could face protests and boycotts from the left. If you remain committed, protests and boycotts from the right, divisions amongst your employees. So it's a really it's a minefield, I think, for in-house counsel. I don't envy them in this current moment. And if we haven't scared you enough, there are a lot of legal developments that are sort of changing this landscape as we go. So it's difficult to navigate, and I think just want to reiterate the message that it's important to stay on top of all these developments and understand where the potential legal liability and legal risk and enforcement risk is coming from, and it can be coming from every single direction. So let's talk about some of the legal developments in this space. Just to give everyone a little bit of a roadmap, what we'll do here is we'll talk about a few recent Supreme Court decisions in this area. We'll talk about some lawsuits that directly challenge the executive order. We'll talk about lawsuits challenging agencies' termination of grants and contracts. We'll talk about DEI in the university space, in the employment space, and then we'll talk about what's been happening with President Trump and various law firms. And if we have time, we'll touch on the state AG. So as you can see, it's a very robust area of law. It will be tough to squeeze everything in this hour, but we'll do our best. And for each category, like I said, I'll try to get Andy's take from the bench. So a few recent Supreme Court decisions that I think are important for the merits of these anti-DEI lawsuits and claims. One is the Harvard admissions case from 2023. I won't get into a lot of detail about that. It's about 2 years old now. But critically, the court held that it is unconstitutional for a university to consider race even as a plus factor in its admissions decision. And even though this is a case about university admissions, there are questions about, what is the Supreme Court thinking in terms of how far that ruling goes? What does the Constitution say about employment or other areas where there may be discriminatory hiring practices, whether it's reverse or normal discrimination. Related to reverse discrimination is the more recent decision in Ames versus Department of Youth Services of Ohio. This is a really interesting decision, again, sort of indicating where the Supreme Court is going. In this case, issued only a week or two ago, the Supreme Court held that plaintiffs suing under Title VII for reverse discrimination, meaning they're a member of a majority, they're white, they're straight, but are still saying that they were discriminated based on those majority characteristics, they have the same pleading burden and burden of proof as a minority bringing the same type of claims. Before the Ames decision, there had been a circuit split, and actually some lower courts had held that if you are a member of a majority group, you actually have a heavier burden to show discrimination under Title VII than you would if you were a minority. What's really interesting about this decision is it's a unanimous opinion by the Supreme Court, and it's written by Justice Ketanji Brown Jackson, who vigorously dissented in the Harvard admissions case. And I think it's an interesting development because, again, even though this case is about statutory interpretation and the meaning of Title VII, it does suggest that certain DEI practices may be unlawful in the workplace or elsewhere where you have an anti-discrimination law that applies to anyone, as most anti-discrimination laws do. And in this case, Justice Jackson highlighted the fact that Title VII applies to any individual. And so essentially she's saying under the statute, everyone has the same burden and will be treated equally in a discrimination claim. So I think this is an interesting case, kind of hinting at where the Supreme Court is going. And then the last decision, it hasn't been issued yet. It's still pending in Skermeti, in which there was an equal protection challenge to state laws that prohibited medical treatments for minors who want gender transitions. This should be decided this summer, and I think it could affect the legality of the Trump gender ideology order and some of the pending cases against that. So you've got, like you said, Andy, it's a very murky area of law. But then you also have the Harvard admissions decision, the Ames case, and then we'll see what happens in Skermeti. But if you're a district court now and you're evaluating one of these anti-DEI cases, how are you interpreting these two Supreme Court decisions? Are you trying to anticipate where the Supreme Court is going to go? Do you have a good sense of where they're going, or are you sort of putting those off to the side and thinking about the particular statute or area of law that you're addressing?
Well, I think with Ames, it gives you pretty clear direction about how to handle discrimination claims. And there has been sort of silently embedded in the law this idea that if you're a non-minority, there's a different standard. Ames helps you as a district court judge, if you're a trial judge, to give you clarity and support that you can treat these the same as any other case. So that's an important decision. I think what you'll see is certainly district court judges more willing to grant as applied challenges than maybe facial challenges. So, for in-house counsel, as applied is really the particular circumstances of the case. Facial would be that the law is unconstitutional in all its applications. You're not trying to strike down the law necessarily in an as applied challenge, but you're trying to hold that it's unconstitutional as to your client or your party. And so I think district court judges will feel very safe within that area. Skermeti's harder to figure. Of course, we have to wait for the decision. That may have a bigger effect on Title VI cases because there's federal grants and federal aid to hospitals. And so maybe that's where that will play out more. As a trial judge, which that's what district court judges are, they're going to be very careful when they step or wade into gender identity and LGBTQ plus issues. It's a very touchy area. So it depends on what they write, Mark, and how they'll handle it. But I think Ames is great for the trial judge and gives him pretty clear direction about how the court would view, and frankly, how circuit courts are going to review their decisions on discrimination cases.
Yeah, I agree with that. And I think that even though Ames is a Title VII statutory interpretation case, I mean, it basically says reverse discrimination is unlawful under Title VII, regardless of whether the employer has, sort of quote unquote good motives that they want to redress past harms or promote diversity. The statutory language of Title VII is clear that any individual who's discriminated based on race has a claim. And so it doesn't matter if you're white or black or anything else, you have the same standard to bring a claim under that statute. I think that sort of logic could be extended further when we're talking about DEI, because many would argue that DEI is in many of its applications is a form of reverse discrimination. So we'll see how Ames is cited in decisions that come down as these issues percolate. So that's really important to follow what's been happening in the Supreme Court. Let's turn to the litigation that the lawsuits that directly challenge the executive orders. So immediately after President Trump issues these 3 executive orders in early January, you get immediate lawsuits naming him as a defendant, seeking to enjoin the executive order, not necessarily waiting for any subsequent agency action, but basically saying the executive orders are on their face unlawful. And I think that's really interesting. I'm going to come back to you, Andy, on that question, because I want to know if you're a judge dealing with a lawsuit challenging the president's executive order, how you think about that. One of the first decisions on this issue was in a case called National Association of Diversity Officers in Higher Ed versus Trump in the District of Maryland. There you had a few groups. One was a sort of an industry group for diversity consultants and professionals. One was the AAUP, which is a higher education teachers union, and also had the city of Baltimore. And they challenged 3 of the key provisions that we talked about. The grant termination provision. As to that provision, the plaintiffs argued that terminating those grants would violate the spending clause because there's no express congressional authority for President Trump to be able to terminate those grants. And they also argued that the definition of DEI is sort of unconstitutionally vague. We talked about that earlier. They also challenged the certification provision that requires federal contractors to certify that they're not promoting DEI with possible False Claims Act liability. And the plaintiffs argued that it violated the First Amendment and the separation of powers. And then lastly, they challenged the enforcement provision, saying that, basically sicking federal agencies on these companies based on DEI is unconstitutionally vague, denies due process, and will chill free speech. Those 3 sort of theories and those 3 attacking those 3 provisions are basically what we're going to see in the other lawsuits. So when we talk about the other lawsuits, that is, I think, the common thread, those sorts of legal theories. In this particular case, though, the district court issued a very, very broad preliminary injunction, basically telling the federal government that it could not block any grants or awards. It couldn't enforce the certification provision at all. It couldn't bring False Claims Act actions, not only against the plaintiffs, but any similarly situated non-party, so anyone in the country. And it also bound not only the defendants named in the lawsuit, but all other federal agencies. So in other words, it enjoined non-defendants against non-plaintiffs. I think that probably should raise red flags. And in fact, it did. The Fourth Circuit stayed the PI, saying that the preliminary injunction was overbroad. And so that's the Fourth Circuit. There's an interesting concurrence there, or 3 interesting concurrences. And this is another theme that you and I will talk about, Andy, which is that 2 of the judges concurred, saying, this is an overbroad PI, but I don't want you to think that I think DEI is bad. It can be good. Sort of offering opinions about what they think about DEI as a sort of cultural matter. Judge Allison Rushing in the 3rd concurrence says, look, this is a really dubious district court order. The claims aren't ripe. They're non-parties. But she also makes a point, and this is the important theme. She says, it doesn't matter what we think about DEI personally. We have to look at the applicable law, whether it's Title VII, whether it's the Constitution, whatever those say about, discrimination. We have to follow the law. And it seems to me that the DEI stuff elicits very strong reactions from people in general, but seemingly from federal judges as well. So Judge Rushing sort of saying, look, we need to look at this as objectively as we can. Now, there are a few other lawsuits, one in the Northern District of Illinois, one in Northern District of California, also similarly enjoining parts of this executive order, notably the PIs were much narrower, so probably more likely to withstand appellate review. But other judges are enjoining parts of the executive orders. Now, there is a split. There's a district court, the District of Columbia, a very similar lawsuit brought by nonprofits that incorporate DEI into their work. And again, they claim that the EOs violate the plaintiff's First Amendment rights and free speech. The judge there held that there was no standing to challenge aspects of the executive orders, and that even where there was standing, that the plaintiffs were not likely to succeed on the merits. One of the interesting holdings, the judge said, look, you can't just challenge entire provisions of an executive order. For example, you can't bring a vagueness due process challenge until you've actually been deprived of a constitutionally protected right. And so in that case, the court rejected the preliminary injunction. And then there have been cases challenging the gender ideology executive order. Again, just on Friday, actually, like I said, there are a lot of fast-moving developments. On Friday, the Northern District of California enjoined the gender ideology executive order with very stinging language and very sweeping relief. So, Andy, let me just get your take on this in terms of a lawsuit challenging an executive order. I think it's rare and it's interesting because these are not agency-level regulations or actions. These are executive orders signed by the president, and they set policy of the administration, but they don't necessarily constitute immediate agency action. So if you're a judge, you get one of these lawsuits, how are you thinking about that in terms of your relationship as a lower court judge vis-a-vis the executive branch? And how are you thinking about it in terms of standing and ripeness and other issues that such a lawsuit would present?
These are tricky cases, Mark, for a district court judge in particular. I think, initially they always raise the question of major questions doctrine and whether there's a clear congressional delegation for the president to act in the first place. So you're thrust immediately into a separation of powers conflict. And most trial court judges, there are some exceptions, don't like to get involved in that fray. So there's just a natural tendency, I think, of a district court judge to probably scrutinize standing and ripeness more carefully so that they don't even have to enter into that issue about that conflict between the executive branch and the judicial branch and the legislative branch. These are pre-enforcement actions, so there hasn't been an injury yet. Now, when you're dealing with First Amendment, obviously it's much broader protection, anything that would chill that First Amendment right. So there's a lot of case law that can support standing and ripeness. In terms of the more, general standing issues about injury, whether the party's been injured. A lot of these are organizations, obviously. It's hard to establish organizational standing. It's maybe the most difficult. Membership standing is easier for actual members or associates. So I think what you'll find with most trial judges is they're going to look really carefully at the ripeness issue. They're going to look really careful at the standing issues. And if they can find a way to bounce the case on those grounds, they're going to do it. If they have to go past that, they're going to tread very lightly. That being said, there are judges, and we read about them every day, who have no problem whatsoever as a district court judge doing it. It's a little foreign to my way of thinking. And I think what's even worse is when those judges charge into the fray and they start offering their personal opinions that makes people lose confidence in the courts. A judge has to constantly pull themselves back from a case and pull their personal opinions out of it. They should never make those statements. And so, unfortunately, we see a lot of that. I know we're going to talk about this later, but these filings tend to end up in the same district courts, in front of a lot of the same judges. But in some, I would tell you, I think most judges are going to follow that framework I said, to carefully stay away from these questions if they can.
Yeah, no, I agree with that. And I think, and we're seeing that disparity right now amongst district court judges, where some are, knocking these cases on standing and ripeness. The case in the District of Columbia, the Fourth Circuit stayed the PI as being overbroad, but there are judges who are issuing very sweeping injunctive relief. Just the other day, on Friday, in the San Francisco AIDS Foundation case, which I mentioned in the Northern District of California, the district court enjoined the gender ideology EO provisions, and the injunction is really remarkable. It basically says not only can the government not condition funding or contract eligibility on anti-DEI compliance, there's even a clause in the injunction that prevents the federal government from even investigating the plaintiffs or modifying or terminating any existing contracts when no specific contracts were even challenged in the case. This was about the executive order. So some judges are sort of getting into the fray and saying, like, we're not even going to tolerate the executive order. Forget what agency action we're trying to target. So I think as those cases play out, I think it's very interesting to see how courts are dealing with just, we don't like Trump's executive order and the plaintiffs don't, and we're going to sort of enjoin the whole thing. And I think that's a really interesting set of cases, and we'll see if any of those make their way up through the appellate courts and what happens. But so let me move to cases that actually do involve specific grants and federal contracts and fundings. And I mean, in these cases, the plaintiffs are challenging the withdrawal of funding that they already had. So I do think that in terms of Article 3 standing, you've got a classic pocketbook injury, and you're challenging agency action. So there's no question about standing there. There are two interesting legal issues, though, with these cases that have been coming up. One is under the Tucker Act, which we'll talk a little bit more about, where if you have a contract claim against the government, that claim has to be brought in the federal court of claims and not in the district courts around the country. And so the government has been arguing in many of these cases that these district courts in California, New York, Massachusetts lack subject matter jurisdiction. And then there's another question. A lot of these cases involve preliminary injunctions forcing the federal government to pay out federal dollars and continue paying on grants and award and funding awards. That's an interesting question to me, just in terms of whether that's an appropriate remedy at a preliminary stage. Normally, when you're talking about giving money from one party to the other, that can be litigated through a final judgment. You don't usually need a PI for money. Usually, it's to stop some other behavior that would cause irreparable harm. So let's get into that, and I'll get Andy your perspective on those issues. And actually, the Supreme Court has given its at least some opinion on this in the stay context. So not a merits decision, but in the state of California versus Department of Education, the Department of Education effectively ended two grant programs: the Teacher Quality Partnership Program and the SEED program for K through 12 education. The state of California sued and obtained a TRO under the Administrative Procedure Act. The court said, look, there was no individualized assessments of specific grants. The executive branch just terminated these programs. What's interesting here is that this case made it up to the Supreme Court, and the Supreme Court stays the TRO. First, it construes the TRO as a preliminary injunction, which I think is important procedurally, because a TRO is normally not appealable, whereas a PI is immediately appealable. So looking at substance over form, the court treated it as a PI and had jurisdiction to stay the order. But two important points of analysis from the Supreme Court. One, the Supreme Court looked at the Tucker Act and said, this is a kind of case that is really asking for an injunction for the U.S. to pay money. That's kind of like a monetary damages contract claim, and that is probably going to mean that only the Court of Claims has jurisdiction, not the district court. And then it also noted that the irreparable harm factors probably don't fall in favor of the plaintiff, where the question is just a matter of getting funding. Again, that's something that could be litigated to final judgment. So the Supreme Court says, look, that we're going to stay the TRO or stay the PI, the factors aren't there on the subject matter jurisdiction and irreparable harm. That decision was issued in April, but notably, lower courts have sort of been going in different directions. So I think we'll see what the appellate courts do, but district courts have actually been distinguishing the California case. So for example, in an NIH funding case, American Public Health and Commonwealth of Massachusetts versus Kennedy, which dealt with NIH grants, the court explicitly distinguished the Supreme Court's stay order in California. Like I said, we were prepping for this this presentation over the last week or so, and there have been so many developments even in the last day or two. Just yesterday in that NIH case that I mentioned, the court issued a very sweeping injunction requiring the NIH to reinstate grants to researchers and to states that were receiving NIH funding. There was no written order in that case, but the government will likely appeal. So we're seeing these sort of funding disputes in a lot of agencies: the NIH, the Department of Education, National Endowment for the Arts, HUD, Department of Defense, Department of Energy. There are all kinds of grants and funds. I mean, there are billions and billions of dollars that are being doled out every day. And so we're just seeing more and more of these lawsuits being filed, and we're seeing some PIs notwithstanding the Supreme Court's decision in California. So Andy, let me get your take on this, on those two key legal questions, the Tucker Act question and the PI question. Zooming out, do you see these as contract disputes, or do you see these as more statutory constitutional claims that can be brought in the various district courts? And then for the PI factors, how do you evaluate irreparable injury when I'm asking you for a PI to force the government to pay me money that I could potentially get down the road?
Well, as to the first question, the jurisdictional issue's a little bit tricky. I'm going to let the listeners in on a secret. Trial court judges don't like to get reversed. And they don't like to have it in writing that everybody can read that they made a mistake. So when it comes to a decision like this, is there some constitutional individual rights mixed in with contractual rights? By and large, I think most of these district court judges are going to err on the side of protecting the individual rights. Now, that's not cowardly on their part. They're just trying to make a record. And frankly, if there is if they make that record, if they step in and protect the individual rights, it goes up on appeal, and the appellate court says, no, you never had jurisdiction in the first place. That's a better scenario for them than to be told, by the way, you should have protected the rights in this case, the constitutional violations. So I think by and large, district courts are going to shy away from this and wait for direction to come up from the circuit courts. In terms of the PI issue, again, it could be a situation where if they don't have the funding, it's tantamount to depriving the First Amendment right. So it's going to be a fact or case by case situation. The PIs that are being issued now by these courts are problematic because a preliminary injunction obviously is looking at certain factors, primarily reasonable likelihood of success on the merits and irreparable harm. And that's what they're focused on. So you can appeal those, as Mark said. That doesn't stop the case. So you still have a case sitting there. The judge may stay discovery, or the judge may well let it go forward. It's not a permanent injunction. And at the same time, a judge is maybe letting a case go forward on some of these tricky factual issues, whereas a appellate court may come down and make a decision on the law that wipes out everything that they're doing in the case. And for the listeners today that are in-house counsel, I'm just going to make your life a little more unpleasant, because these PI decisions are not going to clarify the law. A preliminary injunction, you can't get declaratory relief. You can't get a statute declared unconstitutional because it's a preliminary injunction. A permanent injunction you can. So you're not getting a definitive ruling on whether these executive orders are constitutional or not. So I think the other thing you'll see, Mark, is I think you'll see more of these judges under Rule 64 say, you know what, we're going to proceed to a permanent injunction. I'll give you 30 more days to do whatever discovery you need. We're not going to do this piecemeal. Let's get it to a permanent injunction, get all the facts out, and then I'll get you a final judgment and declare this constitutional or not. So I think that's what we'll see. In terms of whether or not you can parse out the monetary damages, there may be some cases where you can. And some of these cases, I don't know though, even the False Claim Act cases, mixed within those grants are some First Amendment rights. I think they're going to err on letting them go forward, making the rulings, and letting the appellate court sort it out.
Yeah, those are all great points. And to your point about the preliminary injunction to the permanent injunction, I do think that the posture of these cases is making the law very difficult to follow, because you get the PI, the case is litigated, but the PI is appealed. You also, I mean, just practically speaking, it's based on the statements in a lot of these orders and from the bench, it doesn't seem like the judges are going to change their mind, even though they're saying the likelihood of success at the PI stage. It seems they're pretty convinced that that they're either lawful or not, and so it maybe makes sense to not go through that step that kind of confuses things, and it makes it tough for the Supreme Court, because now it's wading in by staying orders, and we're not really getting to the final resolution of these cases, and that's what makes this confusing. We do have two questions, but before we move on to the next topic, we have two questions about sort of the contract clause and the question about government interfering with contract. The contract clause is applicable to the states, not to the federal government. So that's one point to Howard Meyer's question. On top of that, I should also just note that the federal government has been arguing in these grant cases that it's not just terminating the contract because the president wants to, but because there are already clauses in the contracts that say if the private party contracting with the government does something that violates the policy of the government, that it can breach the contract or end it. And so there's a separate argument that this is a contract case because the government is just invoking its right to essentially terminate a contract, as two private parties could when there's a material breach. Then Matthew,
Let me just add on that.
please.
I want to dovetail on that. A lot of those turn on the non-discrimination clauses in the grants and the contracts. And so if you avow in getting a grant, for example, that you're not going to discriminate, and then you use that grant to discriminate in the training that you do, for example, that's what they're hanging their hat on.
Yes, exactly. So there are interesting questions, and it's a good question, Howard, about how this sort of contract clause issue is being resolved. Matthew Arnold has a question about political question doctrine. How do these injunctions mandating spending escape the political question doctrine? Are these not matters of policy best left to the elected branches? I mean, again, I agree with you. My view of these cases is that they are contractual in nature, and that if the government breaches this contract, you can be awarded damages at the end of the line for a period of time that the contract was breached. But it's odd to me that a district court could enjoin the government to spend money. So I do think political question is an interesting doctrine to sort of see a lens to see these cases through. I haven't given a ton of thought, but it is one way to think about it. Separation of powers being another, where you have a judge telling the government to, spend money out of the public fisc rather than pay damages in a court of claims lawsuit. So with that, let's now talk about the Department of Education and universities. We talked about Department of Education grants, but I want to talk just about Title VI and the Department of Education's Dear Colleague letter from February, directing all publicly funded schools to cease efforts to circumvent prohibitions on the use of race. In other words, the Harvard admissions case, basically, and using any proxies for race, and threatening the revocations of funds under Title VI. There is a DEI portal for students to report instances of discrimination. There have been Title VI investigations into 45 different universities announced in March. And I think this is critical because obviously, this is one of the key battlefields for DEI. I think academia is really the laboratory in which DEI was created, sort of the original source of it, and it's where it's proliferated the most. And we're seeing, this being a huge issue after the Harvard admissions case, but also after October 7th, when we saw an explosion of anti-Semitism, the sort of anti-Israel, anti-Semitic views that you're seeing on campus dovetail with often with DEI, and so there is a close relationship. And I think it's all one big issue that schools are having to deal with. There have been challenges to the Dear Colleague letter. Because of time constraints, I won't talk too much about them. But Andy, let me just get your take on this. Under Title VI, schools have an obligation to provide a non-hostile educational environment. But there's a countervailing interest also in academic freedom, and often speech will make people uncomfortable. I'm not going to suggest that this is an easy line to navigate, but I do personally think that schools have been a little hypocritical about that when they've been sort of very willing to restrict speech when it was offensive to certain minorities. When there is disruptive or anti-Semitic conduct, they sort of suddenly stand behind the First Amendment and say, look, we're free speech zones. The Department of Education shouldn't come after us. Can you, and both of us litigate in this area, so can you give us your high level take about DEI and anti-Semitism and the Department of Education's role in sort of navigating this area?
Well, so the Department of Education has the OCR Office of Civil Rights that enforces federal civil rights laws under Title VI, and that's federal programs, primarily schools, but also hospitals, things like that. It has been a double standard. I don't know how else to put it. And these anti-Semitism cases have brought it to bear. Quite frankly, I'm just going to say it. Some of the discrimination and hostility that Jewish students have faced on campuses would never be tolerated for any other group. If it were a group of Black students or a group of LGBTQ plus students, it would never be tolerated. And so I think that these universities have to really look themselves square in the mirror and say, are we really enforcing the rules here? Or do we have a double standard? And I mean, if like at Harvard, a Black student had been thrown to the ground and held by a group of white students, the action by the university would have been swift and it would have been severe. And that's exactly what happened in Harvard and some other places. And so I think we are really testing now, do the laws and rules apply the same across the board? And unfortunately, these universities, colleges, higher education, they have become so dedicated to the concepts that are embedded in DEI, they've forgotten about protection under Title VII and Title VI. And I'll just go one step further and say, we've always had a line between protected and unprotected speech. Incitement is not protected speech. Threats are not protected speech. speech made in the course of committing a crime, such as an assault. I'm going to shoot you. That's not protected speech. And so I think we're going to have to get to a place where these universities, the way they're applying free speech, it is swallowing up literally equal protection, because Title VII and discrimination under Title VII is essentially equivalent to the equal protection clause. So it's a constitutional protection as well. As well as all of our other laws that we have, Title VI, Title VII, civil rights laws. So it's Mark, you see it, I see it. And I think the way this country and the way the courts and the universities respond to this violent anti-Semitism on campuses will be a test as to whether we really mean what we believe in terms of protected status and equal protection under the laws.
Yeah, great points. And you mentioned Title VII. I think maybe we shift to that since we're running out of time. And that'll be an area of interest for many in-house counsel listening in. Just before we get into some of the developments in this area, can you just talk a little bit about, and you mentioned it already, but the difference between Title VI and Title VII and what enforcement looks like under Title VII?
Yes. So Title VII prohibits discrimination in the workplace, and that could be a private employer or a public employer. And the investigatory and enforcement arm is the EEOC. Now, there are times where if it's a state law, or a state institution, I should say, actually the Department of Justice can step in and enforce the discrimination laws. And we're going to see that, I think, in the coming months, where Title VI deals with federal aid programs, primarily higher institutions of higher education. And so they are dealing with administering grants and activities and services, that type of thing. They do have this Office of OCR that can act in enforcing the discrimination laws under Title VI. Title VI discrimination categories are more limited than Title VII. The biggest difference is Title VI does not protect religion. Title VII does. So these are two that go hand in hand. And so what you'll see, Mark deals with this every day, is with these universities, there are Title VII claims if it's professors, that type of thing, and also Title VI claims that go hand in hand with it.
And you mentioned religion. I do think, though, there has been guidance from previous administrations that Jews are covered by Title VI, even though it's not explicitly in the statute, right? And so
I think race and national origin.
Oh yeah, right. Okay.
That's the biggest difference. So you see DOE and the EEOC a lot in these cases. They have sort of overlapping when it comes to the university authority.
Yeah, and I don't recall any university raising the argument that Jewish students wouldn't be even covered under the statute. Typically, they'll go right to the merits. So those are important distinctions, but let's talk a little bit about the EEOC, because as you mentioned, it is much more affirmative and aggressive than it's been in the past. It's rather than issuing right to sue letters, it's launching its own investigations. It's publicly announced several investigations, which I think is not typical of the agency. It's launched investigation into Harvard's hiring practices for DEI. It sent letters to 20 major law firms asking about hiring and DEI practices.
It's sent letters. It's investigating in UCLA as well, Mark.
Right. And so this is, and you mentioned that this is sort of unique. Can you tell me, if for in-house counsel, does that change, your strategic thinking about how you deal with DEI? Are your sort of, are you more attuned to these issues because the EEOC is getting more involved rather than just you're having to deal with individual plaintiffs? What is the enforcement environment like from your perspective?
Yes, no question about it. So it is what they're doing, and I've seen it firsthand, is they go right in and they start interviewing the claimants who have made the EEOC charges. They'll do full-blown investigations, and they're starting to do this in some cases, actually begin to take up the cause of the claimants. Now, you didn't see that very often in the past, sometimes, but it's very aggressive now. So as in-house counsel, you can actually find yourself, based on the decisions that you made and with the employer you're working with, you might have made a safe decision, that there wasn't discrimination or not to take certain actions, but now what you've done is going to be scrutinized by the EEOC and maybe the DOJ as well. So it's a different environment from even 2 years ago or 18 months ago, where literally plaintiffs, not in all instances, but in many instances, would go to the EEOC just to get a right to sue letter. They didn't expect any enforcement. They didn't expect any investigation. And now they're getting a very robust investigation and even reasonable cause letters. And then you have DOJ coming in and looking at these. And it can even develop into a situation where actually DOJ files the lawsuit and the individual plaintiffs intervene. And so now you really, it's a different calculus, Mark, as you've seen and I've seen, than even 18 months ago or 6 months ago, for that matter.
Absolutely. So it looks like we're coming to the end of the hour. We have 9 pending questions. Unfortunately, we won't be able to get to all those. Maybe that's an indication that FedSoc should have us back to do another update. I'll just very quickly mention the other topics we would have gotten to, which is the Trump battle with major law firms and the settlements with some big law firms in which they've agreed to contribute money towards pro bono legal services, resources towards those sorts of causes and to end DEI. That's been very controversial. And then there have been other agencies like the FCC, which has sent letters to Disney and its parent company, ABC, about DEI practices and affinity groups and things like that. Verizon has committed to ending DEI as part of getting FCC approval to acquire Frontier. There's movement in government employment where government employees have sued because they've been terminated. Unfortunately, we didn't get to the state AGs either. That's a big area for me and you, Andy. But in-house counsel should be aware that both blue and red state AGs are very active in this field. And so with that, Andy, let me ask you if you have any final words, and then we can turn it over to Caroline.
Good luck.
Great. Well, on behalf of the Federalist Society, I want to thank our speakers for the benefit of their time and expertise today. Thank you also to the audience members who joined us. We greatly appreciate your participation. Check out our website, fedsoc.org, or follow us on all major social media platforms at FedSoc to stay up to date with announcements and upcoming webinars. Thank you once more for Oops, I froze.
Oh, I guess that's our cue, Andy.
Okay. All right, Mark.
Thanks,
Well done.
FedSoc.
Good job.
Thank you. You too.